Okay, imagine you've already put in, all that significant work searching the patent landscape for your invention. You've got a good handle on what's out there.
Yeah, that initial search is a big step.
Right.
Yeah.
And now you're looking at protecting that invention internationally using the Patent Cooperation Treaty, the PCT. Wouldn't it just feel incredibly inefficient if you had to start that whole search process all over again?
Oh, absolutely. That would be frustrating. And well, thankfully, the system actually provides ways to avoid that kind of redundancy.
Exactly. And that's precisely what we're diving into today. We're continuing our exploration of the Manual of Patent Examining Procedure, the MPEP. Specifically, we're zeroing in on Chapter 1800, which is all about the PCT framework. And our focus within that today is a particular section, MPEP Section 1819.
Section 1819, it's pretty practically titled Earlier Search.
Yeah, straight to the point.
It really is. It's the part of the manual that lays out how you, as an applicant navigating the PCT process, can potentially get credit or at least have the International Searching Authority consider search work that's already been performed on a related application.
And for this deep dive, our source is, well, the official MPEP text itself, covering this specific section.
Right. And our mission today is to really unpack this section for you. We want to help you understand the core concept, leveraging that earlier search.
Walk through the requirements for doing it.
Yeah, explore the procedural details and ultimately highlight why understanding this specific bit of the MPEP is just, well, crucial for making your international patent application process smoother, more efficient.
So let's start with the big picture then. At its heart, what is the main goal of MPP Section 1819?
Well, the core idea is really efficiency. Efficiency through recognizing prior work. It allows you to formally request the International Searching Authority, the ISA.
That's the entity doing the international search for the PCT application.
Exactly, the ASA. You can ask them to take into account the results of a patent search that was already done.
And this isn't limited to just, say, a previous international search, is it?
No, not at all. That's a key point. The earlier search could have been an international search, maybe on a previous PCT application you filed.
Okay.
But it could also be what's called an international pipe search, or even just a national search performed by a patent office on a domestic application related to your current PCT filing.
So different kinds of searches count.
Yeah. The key is that relevant search work has already been completed by a competent authority.
Okay, so the system allows this. It makes sense.
Right.
But how do you actually make this request official? What are the formal steps involved?
Right. This process is primarily governed by PCT Rule 4.12. You can think of this rule as setting the kind of foundational requirements for telling the ISA, hey, I want you to look at this earlier search.
And what's the absolute first thing you need to tell them under 4.12?
You must specify the office or the authority that conducted that earlier search.
Right.
The ISA needs to know who did the work you're pointing to. Was it the EPO, the JPO, the USPTO? You have to name them.
That makes sense. They need to know where to look,
Yeah.
basically. And presumably, you also need to give them a way to find the specific search results, right?
Precisely. Along with identifying the office, your request must include the associated application number for that earlier search.
The application number.
Yes. This links your current PCT application back to the specific previous work. Without the correct application number, the ISA would have no real way of identifying the relevant search report or the documentation.
I see. So identify the source of the search, the who, and provide the key to unlock it, the application number. Is there anything else you can include in that initial request?
Yes, Rule 4.1 also mentions an optional statement. You may include a statement affirming that the international application you're filing now is substantially the same as the application that was searched earlier.
Substantially the same.
Yeah.
Okay. And what if there are some minor differences? Maybe just language tweaks or something?
Yeah, you should note those differences, especially if they are purely linguistic or maybe only relate to the designated jurisdiction.
Why is that helpful?
Well, this statement helps the ISA examiner understand the degree of relevance of that prior search. If the applications are, essentially identical in their technical disclosure, then their earlier search results are obviously much more directly applicable.
Got it. Okay, so you've made the request under Rule 4.12. You've identified the office, provided the application number, maybe added that statement about sameness. But how does the ISA examiner actually see the results of that earlier search? Do they just, take your word for it?
No, not usually. This is where PCT Rule 12 comes into play.
Rule 12 bis. Okay.
Right. This rule details the procedural requirements for providing the evidence of that earlier search. Rule 12 typically requires that you must provide a copy of those earlier search results.
So you need to actually send them something.
Generally, yes. You usually need to submit these along with your international application when you make that initial request under Rule 4.12.
And what exactly counts as earlier search results? Is it just one specific document, like a report?
It can take various forms, actually, which Rule 12 best acknowledges. It might be the formal search report itself that was issued in the earlier procedure.
Okay.
Or it could be just a simple list of the prior art documents that were cited during that search.
A list of citations.
Yeah. Or maybe if it was a national phase application that went through examination, it could be an examination report that discussed the prior art found during the search phase. The main goal is to give the ISA the specific documents that identify the relevant prior art the previous authority found.
Okay, so you need to provide the actual paperwork in whatever form it takes. What about language? This is international after all. What if the earlier search was done by, say, the German Patent Office, but your PCT application is in English, and maybe the ISA is the USPTO?
That's a really crucial point, and it can definitely add a layer of complexity and sometimes cost.
Right.
If the earlier search results themselves, or even the original application that the search was based on, are in a language that the specific international searching authority you've chosen does not accept for search purposes.
Which they define.
Yes, they have lists of acceptable languages. If it's not one of those, then you must provide translations of those documents.
Translations. Okay, that could be significant work.
It can be. But it's necessary to ensure the ISA examiner can actually read and understand the cited prior art and the reasoning behind the earlier search findings. It's a key step to make the earlier work genuinely usable by the ISA.
Makes perfect sense. The examiner has to be able to understand the documents they're looking at. So recap. Identify the search, provide the application number, submit copies of the results, and translate them if needed. That sounds like, well, potentially a fair amount of documentation work.
It can be.
Are there any situations where these requirements, particularly sending copies and translations, might be waived or simplified? Any shortcuts?
Yes, absolutely. And this is important. Rule 12b's includes some significant exceptions, which can save you quite a bit of effort and potentially cost.
Okay, let's hear about those. What's a key waiver scenario?
One big one happens if the same office is involved in multiple roles. Specifically, if the office that conducted the earlier search is also acting as both the receiving office for your PCT application and the international searching authority for that application.
Ah, okay. Like if the USPTO did the first search on a U.S. application and you file the PCT designating the USPTO as both receiving office and ISR.
Exactly that scenario. In that case, they theoretically already have access to the records of the earlier search they conducted. The MPEP confirms that in such a situation, the requirement to submit a copy of the earlier search results may be waived.
Okay, so if it's the same office wearing multiple hats, they might already have the info internally. That tracks. What's the other main situation for a waiver?
The other key situation relates back to those optional statements you may make under Rule 4.12.
The one about substantial sameness.
Yes. If you make specific declarations under Rule 4.12 and 2, like stating the international application is substantially the same as the one previously searched, and you also clearly indicate that the earlier application or its search results are available to the ISA.
How would they be available?
Well, perhaps through a digital library system, like WIPO.
Right, the Digital Access Service.
Exactly. Or maybe simply because the earlier application is being claimed as the priority document right there in the PCT application itself. If you indicate this availability, then the requirement to submit copies or translations may also be waived.
Ah, okay. So this is where understanding the interplay between Rule 4.12 and Rule 12 becomes really valuable.
Yeah.
It's not just about making the request, but also knowing how you might streamline the process of proving it.
Exactly right. And these waivers really highlight how the system tries to avoid redundant paperwork when the necessary information can reasonably be accessed by the ISA through other established means.
Let's try and tie this all together with a concrete example, maybe one that's particularly relevant for applicants here in the U.S. who might have started their patent journey domestically first.
Yeah, a very common scenario involves a U.S. applicant. Let's say you first filed a national patent application directly with the United States Patent and Trademark Office, the USPTO.
Standard first step for many.
Right. Then later, you decide you want to seek patent protection internationally via the PCT, and you file a PCT international application.
And you want the USPTO, which can act as an international searching authority for PCT application.
Yes, it's one of the available ISAs.
You want them to consider the search they already performed on your U.S. national application.
This is a perfect use case for MPP Section 1819. You would formally request this under PCT Rule 4.12 in your international application paperwork.
Okay.
You would specify the USPTO as the office that conducted that earlier search, and you would provide the application number of your U.S. national application.
Now, you mentioned something earlier about international type searches at the USPTO. Can you elaborate on that specific detail?
Yes, this is an important point specific to USPTO practice. For U.S. national applications filed on or after June 1st, 1978, the USPTO automatically conducts what is considered an international type search.
Automatically?
Yes. It means that for many U.S. national applications that could later serve as the basis for a PCT application, especially if you're claiming priority from it, a search that's generally comparable in scope to a PCT international search has already been performed by the USPTO as part of the national examination.
So what does that mean for the request?
Well, the MPEP clarifies that because this international type search is automatically linked to the national application, you don't need some separate special identification number just for that specific search in your Rule 4.12 request. Citing the U.S. national application number is enough.
Okay, that simplifies things a little bit. Good to know. And what about the requirement to provide copies of the search result or translations in this specific U.S. application to USPTO as ISS scenario? Do you still need to dig up and send them copies of the U.S. search results?
This is exactly where those waivers we discussed can kick in.
Ah, right.
If that earlier U.S. national application is already available to the USPTO, acting as the ISA, perhaps because, well, the USPTO is the office that handled the original application, and it's right there in their internal systems.
Or maybe through that digital library.
Right. Maybe it's available through a digital library system like WIPO DES, especially if you claimed priority through DAS, or simply because you've properly claimed it as the priority document in your PCT application itself, which gives them access. In those cases, you may not need to submit additional copies of the search results. And assuming the U.S. application was in English, no translation needed for the USPTO.
Yeah, the critical condition there.
Catch. The crucial condition is that you, the applicant, must clearly indicate to the USPTO, as the ISA, that the earlier U.S. application and its search results are available to them through these means.
So you can't just assume they'll figure it out.
No, definitely not. You can't assume they'll connect the dots or go digging for it without being prompted. You need to explicitly state in your request, usually on the request form itself, that the earlier application information is accessible to them. This fulfills the requirements under Rule 12Bs for indicating availability.
Got it. So bringing this back to you, the listener, who might be navigating or just thinking about the international patent process, why should you really care about this specific, seemingly quite detailed section of the MPEP? What's the takeaway?
Well, understanding MPP Section 1819 is fundamentally about smart strategy and efficiency. The whole point of the PCT process is to streamline international filing, and this section is a key part of that streamlining potential.
Makes sense.
By leveraging search work you've already potentially paid for and had performed, you can possibly save a significant amount of time, effort, and maybe even cost during the international phase of your application.
Yeah, those searches aren't trivial undertakings.
Not at all. Conducting a thorough patent search requires considerable resources, time, and expertise. So, if the ISA can effectively utilize a search that's already been done because you've correctly followed the procedures laid out in MPP Section 1819 and the associated PCT rules, it can potentially expedite the processing of your international application.
How so?
It gives the examiner a strong starting point. They aren't starting from absolute zero. This could potentially lead to quicker examination, maybe clearer results in the international search report, and potentially smoother sailing in the national phases later on. It's really about getting the most value out of the work you've already invested.
It's kind of like getting a head start on the track and making sure the officials actually recognize the mileage you've already put in.
Precisely. That's a great analogy. It avoids reinventing the wheel and lets you build on existing efforts, all within the structured framework of the PCT.
Well, that was a really insightful deep dive into MPP Section 1819 and how applicants can navigate these earlier search provisions. Really useful stuff.
It's definitely a section packed with important procedural details, things you have to get right. but the strategic benefit, I think, is quite clear.
Agreed. And before we wrap up, we'd like to extend a special thank you to Mike Shepard, the creative director who organized this entire audio series.
Yes, thank you, Mike. And now, just a brief but very important disclaimer regarding the nature of this discussion.
Disclaimer. This summary of the MPEP was generated using AI tools, including ChatGPT and NotebookLM, and may contain errors or omissions. It's provided for general educational and informational purposes only, and is not legal advice or a substitute for formal instruction. For authoritative guidance, consult the official MPEP, a qualified instructor, or a registered patent practitioner.
And finally, as always, here's a little something for you to consider as you reflect on today's topic.
Okay, so we've talked about how to request consideration of an earlier search. But given all the detailed requirements, like potentially needing to demonstrate substantial sameness between applications and navigating the procedural steps for providing documentation or indicating its availability, what strategic considerations might lead an applicant to decide against requesting the ISA consider an earlier search, even if they technically could, and instead just choose to let the ISA conduct a completely new international search from scratch? When might that be the better play?